Tracy, can you hear me?
I can hear you. Do you need me to walk you through how to assign me as captioner? Reggie, can you hear me?
All right, so good morning, everybody. We're going to go ahead and get started. So before we do a public comment, I'm just going to offer a brief introduction. So good morning, and thank you for joining us here today. My name is Reginald Parson, and I'm the Deputy Director with the Maine Paid Family and Medical Leave Program. I'll be facilitating today's public hearing. With me are my colleagues Luke Monahan, Director of the program, Sarah Brighton, Program Division Manager, and Sophia Cleed, Management Analyst. We're here today to hear your comments on the department's second version of the proposed Chapter 1 rules governing paid family and medical leave. The process for rulemaking, including today's public hearing, is governed by the Maine Administrative Procedures Act. Today's proceeding is also being recorded. We'll publish the comments received from both the first and second version of the proposed, we'll publish the comments received from both the first and second public comment period and our response to them on the Department of Labor's website within 3 days of the rules being certified by the Secretary of State. The process today is for us to hear and capture your comments on the sections of the proposed rule that have been materially changed. It is not meant to be a forum to answer questions or to come to consensus on the rule as proposed. However, I may ask clarifying questions to ensure we capture your comments accurately. Participants who are physically here today who wish to comment will be allowed up to 3 minutes to speak. Participants will also be given a 30-second warning prior to the conclusion of the 3 minutes. And just so as a little background about that, so Sophia here, when you're at the 30 seconds, she'll lift up a yellow folder, and then at the conclusion of the 3 minutes, you're gonna hear a loud beep, but also she'll hold up a red folder as well. When you speak, please begin by telling us your first and last name, as well as the town you are from, or the organization or association you are representing. Finally, if you have not signed in on one of the sign-in sheets available upon entering the room, please do so now or at the end of the hearing. Speakers must refrain from engaging in disruptive conduct, including but not limited to using vulgar or obscene language, threatening others or using words or by others' actions, using pejorative or discriminatory language, making defamatory comments, and offering comment on matters unrelated to the purpose of this hearing. Finally, written comments can also be submitted online through the Department of Labor's website at www.maine.gov/paid leave and is also posted on the whiteboard behind me. The comment period ends on Monday, September 30th, 2024 at 5 p.m. So with that, are there any questions? Okay. Great, so I'm just going to take a brief pause because I need to switch the camera over so as folks are talking, so please. We're almost there, sorry. All right, so now at this time, if there's anyone who wishes to offer public comment, please feel free to do so. And the 3-minute clock will begin.
It's not last time, so I'll do it again. I'm handing in comment both for us
Yeah.
and for a member.
Okay, perfect. Yeah. Thank you.
Good morning. My name is Krista West. I'm a resident of Reed Field, and I'm here today to present comments on behalf of the Maine Forest Products Council. The council appreciates the opportunity to provide comments on a second draft of these rules, as they will have a significant impact on employers of all sizes in every corner of the state. While we certainly appreciate the progress the department has made to address the concerns of our members, many issues remain with the rules in their current form. Several rules still lack the clarity that is needed prior to implementation. Others make it next to impossible for operations to continue at their current capacity, and fraud remains a very real threat to the viability of the program. Our written testimony lays out some specific questions and concerns, but rather than reading all of them today, in the spirit of time, I've picked out just a few to highlight. Penalties for employees who are found guilty of fraud are inadequate. For example, there's not a sliding scale of penalties to discourage repeat offenses for those found guilty, and they're not even required to pay the fund back. That threatens the solvency of the fund. The rules should require a waiting period in between qualifying events. Otherwise, employees could utilize the program through intermittent or reduced scheduled leave on an ongoing basis. In addition, they should be required to exhaust their sick leave before dipping into this program for the purpose of reduced leave or intermittent leave. Affinity relationships, while they've been removed and replaced with significant personal bond, the definitions are still too broad. For example, geographic proximity is not an appropriate indicator of a family-like bond, and it's too openly defined. What proximity is considered an indicator of a relationship? Is it a mile within the town, the same county? There's only just over 1 million people in the state, so arguably everybody is within geographic proximity. The only previous guardrail on this, the one designee per relationship, has been removed. There's still no requirement for the person being claimed as a designee to agree to the arrangement, and nothing prohibits multiple individuals from claiming the same person for the purpose of taking leave. We strongly encourage the department to refine this section further. We also encourage the department to amend the reasons for leave section to include the requirement for documentation from a healthcare provider confirming the serious condition for the person of which is being claimed to take leave for. The rules are written in a way that locks employers into specific private plans without allowing for flexibility to change plans once an exemption has been granted. There are many legitimate reasons why an employer may seek to change plans, and they may benefit both the employer and the employees. That's all that I'll talk about today. As I said, there's more in our in-depth written comments.
Thank you.
There we go.
Thank you.
How are you, folks? I'm Betsy Olton. I'm here on behalf of the Maine Local Government Human Resources Association, specifically talking about municipalities, counties, and some school departments. Thank you for taking all of our probably thousands of comments in the past several months. A couple of things that we just wanted to make note of, specifically in your FAQ section, under the collective bargaining agreement section, it indicates that if a contract is has not been expired, they are not required, nor their employer required to contribute to the fund, nor perhaps utilize the benefit until the contract has expired. The question becomes, oftentimes when the contracts are expired, they often aren't ratified immediately, and they're often held over up to, sometimes a year or two. The question becomes, when do the contributions begin? When can these employees actually use the benefit? So that's one sort of clarity that this group is seeking. And if they do pay into the fund immediately, once the contract is ratified, or regardless of when that is. The other concerns that we didn't see sort of addressed in these latest rules were as far as the municipal government and also the school departments, specifically hiring a camp counselor or lifeguard during the summer. It's understood that all of these folks are employees and would be eligible for the benefit. The concern is that the 12 weeks typically will be longer than the actual employment. So just trying to understand the employees such as election workers, such as school board and committees that are paid and they're considered paid employees, these types of stipended positions, and how that's going to work in terms of number one, contributions, and also the usage of the benefit, and how the employer is going to be able to maintain operations during this period of time. The question also comes up regarding substitute teachers. So if there's a teacher that's out on a leave and a substitute teacher is going to fill in, and then they need to leave, sort of how is that all going to work in terms of the absent teachers in the school districts? If a school employee experiences a medical condition in the summer, does the paid leave start once school begins? How does that work during the summer break? Some school personnel, sorry, am I up?
You can.
Just my final thought was just some school personnel actually can decide whether they're going to be paid over the course of the summer or they're not going to be paid during the summer, and how does that sort of impact? My final quick question, I think Reggie, I raised it also under the wage section. What we're really struggling with, what constitutes a wage, especially in municipal world where they have insurance buyouts. That's a form of sort of added compensation. Will that be included in the wages, as well as on-call and those types of payments? Thank you so much for your time, and we'll send any follow-up questions.
Thank
Appreciate
you.
it.
Do you want paper copies?
Yeah, sure, we can take them after you're done with it.
Good morning. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association. I think we have 15 different comments. I will try to highlight 3 or 4 of the important ones. First, we'd like to say thank you for the changes that you made. We appreciate them. Several of them were changes that we sought, and so we appreciate the changes that you have proposed so far. We continue to oppose, as representatives of private option employers. Many of our hospitals will probably opt for the private option. We continue to oppose having to pay a quarter's worth of the tax if we're not using the program. On a related item, you have as the effective date of the tax exemption the date the DOL approves the private option application. I think as a general rule, we don't oppose that, but for 2025, we do. It should be the date of the application is received. You're probably going to get a crush of applications in the second quarter, and it's going to be luck who gets approved within that quarter. That's a fairly substantial tax hit based on luck. So for 2020, we would recommend you use the date the application is received. Remaining on private option plans, it appears to us that you've changed the statutory requirement for what qualifies as a private option plan. you have inserted into the rule a standard that the plan must provide greater, equal to or greater benefits than the state plan. That is not what's in the statute. What's in the statute is substantially equivalent. The phrase that you use in the rule, greater aggregate monetary benefit, is not in the statute. I don't think you have the authority to change it from substantially equivalent to greater or equal to. The rule properly prohibits someone from taking paid leave at the state level if they've already taken unpaid leave at the federal level. Unpaid federal first, you ban paid state leave. You do not do it in reverse. You can. I think there's a way for you to properly prohibit someone from taking unpaid federal leave after they've taken state paid leave. If you don't, people can take 24 weeks of leave. I'm quite sure the legislature was not thinking that would be possible. Many of my comments, I think, are reiterations on the original rule. One final comment, if I may. The rule anticipates that you will investigate complaints, but it in no way spells out how complaints are to be submitted or that you even have to accept complaints from the public or employers. I think that the process related to complaints should be spelled out so the public knows what's expected of them and filing something with you for your consideration. Again, there's a lot more in our written testimony, and I appreciate you letting me go over. I also have for you one of our membership groups, Northern Light Health, that have written comments as well.
Okay, thank you. Yeah, you can hand it to Sophia.
Thank you.
Thank you.
Good morning. My name is Patrick Woodcock. I'm the president and CEO of the Maine State Chamber of Commerce. Let me first begin by saying it's been a busy summer. We were here about 3 months ago, and the Maine State Chamber of Commerce does want to recognize the incredible work of the staff of the Department of Labor in responding to comments and taking them seriously. The rules have gone under substantive changes, especially with respect to private plan implementation, which we believe is closer to the legislative intent of the statute and more closely mirrors the best practices in other states. I would associate myself with Mr. Austin's comments. We do have continued concerns with the first quarter and the timing of approval that could have some significant impacts on specific businesses. We also did want to say that we appreciate the additional comment period that brings us here today. This is the most significant rulemaking the state has gone, in my estimation, in 20, 30 years. And it is important that we have the public's input to get the rules right. There are 4 areas that we'll be including in our written comments and that are in my public comments today. I do want to use my time to talk about the undue hardship provision, which we continue to have some concerns of how it will be operationalized, both from an employer and from the Department of Labor. I just want to repeat the sentence in the statute. I've read it probably 100 times, and I want to acknowledge that it is being built from scratch in the rules. So this is a hard challenge, but let me repeat the sentence in the statute. Use of such leave must be scheduled to prevent undue hardship on the employer as reasonably determined by the employer. The plain language is crystal clear in the statute. Now, operationalizing that on what is reasonably determined by the employer is hard. The rules make some progress, but includes a provision that it is unreasonable to make a determination that it is an undue hardship if the employee requests the leave 30 days prior to the leave. I don't have to tell you from employers that there are examples throughout the state of Maine where there is a reasonable hardship that is foreseen within 30 days. One example, the busiest time of year is a retailer. 30 days from now, somebody requests November 1 in 30 days for leave. If I could finish the comment.
Yeah.
That clearly is the busiest time of year for that employer. And it's, as a plain reading of the statute, a reasonable hardship on that business. For a harvest of a fishing vessel that is the most productive area, it is plainly written that it is supposed to be the employer that makes the determination. In conclusion, we are concerned that the provision, which was a significant request from the business community, could be reduced to a meaningless aspect of the Maine paid family medical leave, which is a specific, unique provision of the paid family medical leave law in the state of Maine. I do want to thank the staff here, and I will provide the comments. Hard to capture all the comments in 3 minutes, but we will be providing written comments on September 30th. Thank you very much.
Thank you. Yeah, you can hand it to. Thank you. Right, anyone else wish to speak?
Good morning.
Good morning.
Happy to be here with you today. I'm Dusty Coleman-Sprague. I represent the Maine Women's Lobby. And I do want to clarify, I sometimes speak on behalf of other groups or coalitions. I'm here today in my capacity as the director of the Women's Lobby. First, I really want to thank the team here and the diligent work you have done to build a program that is going to work for all Mainers. We know that paid family and medical leave is a system that works. It works in every developed country in the world. It works in multiple other states. And in most states where it's been underway, they've seen huge improvements in maternal health, child health, and small businesses. So we know that this program works and is going to continue to. And I appreciate the work you've done in hearing from all stakeholders to build a neutral system. We do have a couple of concerns with some of the changes, and I wanted to speak after my colleague, Mr. Woodcock, because I am also especially focused on this undue hardship section. Folks may not be aware, who aren't as familiar with this program, that no other state in the country offers an undue hardship, and they all have successful functioning programs. And private plans don't offer undue hardship. That is primarily because when you allow individual organizations to create their own rules, it opens the door for discrimination. We know at the Women's Lobby that 40 years of our work to build a more equitable workplaces shows that inconsistent standards open up that door, intended or otherwise. When the person with more power, in this case, the person who signs the paycheck, sets their own standards for appropriate scheduling, it's primarily women and marginalized BIPOC workers who are left behind. We also want to flag, so, standardizing the amount of time feels just so important for clarity. We also want to flag that the changes in undue hardship move this portion into the application section. This is great in cases where there is no conflict because it streamlines the system for everyone. But we're not talking about places where employers recognize that this is good for them and their workforce. We're only talking about situations where there's a conflict, where it's going to be a problem. Moving that conflict into the application process can slow down and delay access for workers. but it also moves that conflict, essentially a labor dispute, into the hands of a third-party claims administrator. We think that all labor disputes should be settled through the Department of Labor. So we also want to flag that we will be submitting longer comments specifically focused on that 10 weeks, which we think is inadequate. Making sure that the leave is available for all people who are eligible because they have been, and have some flags around ensuring that the safe leave is accessible, is part of emergency definitions. So we have more information about that, but we really want to thank you and your hard work.
Thank you. Still, oh, okay.
Jean Wood from Alliant Insurance. I live in Green, Maine. My organization will be submitting written comments by September 30th, but I did have one question to follow up on the comments from the Maine Hospital Association and the Chamber about the private option. And my question is, it's unclear to me why the delay to file for approval of the private option until April 1st. It just seems that we could get some of that work done in advance so that you all are not faced with a deluge of applications on April 2nd, which then would, kind of spill over into the end of the quarter. It's going to be very difficult for employers to wait and try to explain to their employees, okay, we took your 0.5% the first quarter, we're going to keep taking it the second quarter, but we've applied for approval for a private plan, and then if we get approval, then we're going to refund your contributions. It just seems like a lot of extra administrative effort if the integrity of the plan can be maintained by giving those opt-outs effective April 2nd or 1st, however that language is interpreted. It just seems like that work can start now. The Bureau of Insurance can start doing some of that work. You all can get that work started sooner to make that a little bit more. And I think that you have the flexibility to do that. So that's really my only question, a comment for today. As I said, we'll have more written comments.
Thank you.
Thank you.
My name is Catherine Buxton. I'm the Policy and Community Engagement Manager for the Peer Workforce Navigator Project. And I want to thank you, as others have, for the attention to detail and the work that you've done to make sure all workers can access this vital program, and for extending that to broad stakeholders as well. I want to note that any changes to these rules should be done with the goal of reducing barriers and creating efficiencies for the workers to access the benefits that they need. That is how we will see real dividends in the Maine economy, and national research shows this, showing that paid leave programs increase employee retention and productivity, creating significant savings for businesses and increasing both revenue and profit for those companies that offer leave versus those that don't. So we need to put in place rules that ensure more workers, not fewer, can access paid leave, so Maine's economy can reap the benefits. And as such, we appreciate the many positive changes the department has made in this area, and will be submitting additional written comments. But today, I want to share a concern that we have about the exclusions in the rule that were added, that we believe go against the intention of the statute and threaten the viability of the program if enforced. So our main concern is in regard to the exclusion of any unemployed workers that are impacted by the addition of the language in section 4A4, stating that eligible workers must be employed as of the date of the application for benefits, etc. These rules should be adjusted to ensure that unemployed workers are also eligible for coverage for family or medical emergencies that come up while they are unemployed, if they are otherwise eligible for the program and have already paid into the system. PWN has a deep understanding of these claims-based benefit programs because of our experience working with unemployment insurance, which PFML shares a lot of foundational aspects. And we know firsthand that denying individuals benefits when they need them most does not serve workers nor prepare them to re-enter the workforce, which we believe is a goal of the program. This change penalizes workers who have contributed already to PFML and denies them benefits that they are already paying for through their premium deductions. It does not benefit businesses either, as they already have paid out these premiums to their former employees. Paid family leave should instead offer Maine workers a safety net to be able to care for themselves, a new child or family member, especially during the economic hardship that can be experienced with job loss. And I'll just share one story of a claimant because I think it's important to center the folks who might be impacted by this. So in one case, an unemployment claimant, Annette will be anonymizing her name because she's an asylum seeker, was let go from a production job just weeks before her due date. And while employed, she had applied to take maternity leave, but felt like her employer targeted her as a new Mainer and let her go because she was pregnant and didn't understand her rights. She wanted to file for unemployment. I'll just finish this story. She wanted to file for unemployment, but because she was due in a few weeks, she found she wouldn't be considered eligible because she wasn't able or available and couldn't work for many weeks after her delivery. And that was devastated to learn that she has so few resources available to her. And had PFML rules been implemented or would be implemented in the way they were originally drafted, this could be a vital and life-saving resource for someone in Annette's situation. Unfortunately, the new rule, as written, excludes unemployed workers, eliminates this lifeline, and frankly goes against the intent of the statute. And we'll be submitting further written comments. Thank you for your time.
Thank you. There's still plenty of opportunity if anyone wants to come up and offer a comment.
Morning, everybody.
Morning.
My name is John Andrews, and I'm here on behalf of Mike Soboleski, who is out of town. So I'll be reading his remarks. Committee members, I would like to express my sincere appreciation for the diligent work you have put into revising the initial draft of rulemaking. Your efforts have resulted in substantive changes that directly address several of the concerns raised during my previous testimony. These modifications demonstrate a commitment to transparency and responsiveness, and I commend you for your dedication. The revised rules have made progress by clarifying the definition of a family member and outlining how businesses can opt out of the state plan if they offer private benefit leave. This reduces the level of discretion required by the Maine Department of Labor and provides clear guidelines for businesses. However, it is crucial to ensure that these rules apply only to full-time permanent employees to maintain consistency and fairness. The proposed 1% payroll tax to fund the program is a substantial economic measure. The revised rules now allow employers to declare private plans at least 12 months earlier than previously allowed. This change aims to reduce the financial burden on businesses by providing more flexibility and potentially lowering costs associated with the program. It is essential to ensure that the funds for this program are utilized solely for the stated purpose and cannot be allocated to another program or outside the stated scope. Implementing strict guardrails to ensure the fund's integrity is paramount. The initial rules detailed complex administrative procedures for implementing the program. The second draft includes more than 15 clarifications and amendments that address various administrative aspects, such as the role of employee leasing companies and the circumstances under which volunteers are not covered by law. These changes aim to simplify the administration of the program and reduce complexity. Ensuring that these procedures are streamlined and straightforward will benefit both employers and employees. The program's rules have a wide-reaching impact, offering up to 12 weeks of family and medical leave benefits over a one-year period. While the revised rules provide clear guidelines on eligibility and the process for taking leave, it is important to address the concerns about the program's broad impact. Limiting the application to full-time permanent employees will help manage the scope and ensure the program's sustainability. Again, strict guardrails must be in place to ensure that the funds are used exclusively for the program. The proposed rules have prompted public concern and debate. The Maine DOL has incorporated feedback from over 1,000 comments submitted by nearly 300 people. And this demonstrates a clear commitment to addressing public concerns and ensuring that the rules are more aligned with the needs of both businesses and employees. Continued engagement with stakeholders is vital to refining the program and addressing any remaining issues. Major substantive rules are subject to formal legislative review. The need for formal legislative review remains a point of contention. Ensuring that the rules undergo thorough legislative scrutiny is crucial to addressing all stakeholder concerns. The second revision, while undergoing a second public comment period, may still lack the comprehensive legislative oversight needed to fully address these concerns. Now, Maine law mandates that major substantive rules must be provisionally adopted and then reviewed by the legislature. The definition of covered employees and the substitution of private plans involves significant agency discretion and have broad impacts. The second revision clarifies these definitions and processes, but significant agency discretion remains. This could lead to challenges in implementation and compliance, as businesses may still face uncertainties regarding eligibility and the approval of private plans. Maine law emphasizes that major substantive rules involve significant agency discretion and interpretation. In conclusion, while the second revision of the rules makes significant strides in some concerns, it does not fully resolve the important issues related to agency discretion, economic impact, administrative complexity, broad scope, public concern, economic impact, legislative review, and the definition of covered employees in private plans. Continuous feedback and further adjustments may be necessary to fully address these concerns and ensure the program's successful implementation. Again, thank you for all the work you've done so far, and thank you for your time and consideration.
Thank you.
What's that?
Yep. Good. Thanks. Good to see you.
Me too. What do you want to talk about last night?
Yeah, no.
Where's that basket for us?
Oh, you can hand it to Sophia.
Thank you, Sophia.
Are there any additional folks who want to offer a public comment? Seeing no one stand up, we're gonna go ahead and conclude the public hearing. So I just want to thank you all for attending today, and hope you have a great rest of your day.